So this week is again a bit of a progression in the capital stack. We've been talking about the three phases of the deal every week. What are they? They're the underlying transaction, in our case, acquisition or disposition of a property, right? They're represented by a contract we call a purchase and sale agreement. So that track is running along. That's the primary transaction. And then underneath that are two other transactions that are running at the same time, concurrent with that one. And they are debt and equity. We're out there doing an offering to raise equity, or we're going to people like our other large capital partners, like preferred equity providers and the like, and I won't mention names since this will be published, but large capital providers, when we do something like we did in TC21 last year, and you guys have a copy of the TC21 PPM, the private placement memorandum or confidential offering memorandum, which we'll talk about in a bit. But that offering for us, our Class A, or what we refer to sometimes generically as our common equity offering, raised about $35 to $38 million, somewhere in that range. But it was a $650 million transaction, and it required about $200 million worth of total equity. The rest of it was debt, about $450 million in debt and about $200 million in equity. Well, we only raised about $40 million of the total equity out of that 200, so the other 160 had to come from somewhere. And it came from equity providers who are either preferred or priority equity providers, institutional players that we do deals with to issue them a big tranche of that capital. In that case, it was something in the range of $100 million and $60 million. Two different providers came in for two different parts of the capital stack in that deal. But the issue here today that we wanted to talk about specifically is in that part of the deal. We talked about debt last week and debt the week before, but in this part of the deal, what we were talking about, thank you, Molly, appreciate that. This week we want to talk about the equity side of the capital stack rather than the debt piece and what debt looks like. So today, instead of talking about securities offerings in general, and if you saw last year's RREAF Academies, I did a securities offering session on securities offerings and talked about private offerings as well as public offerings and the acts, the federal and state securities acts that we issue under as a result. And so instead of doubling up on that and basically redoing that one, the thought was that you guys would have access to those and you could see those in advance and probably have been through a number of them, if not all of them. And because of that, we can move into a different topic here. So today, we're going to talk about securities offering disclosure, not the offering itself and the exemptions and how we work through those exemptions and the exemption schemes. Because here at RREAF, we don't do public offerings. We don't do registered offerings that would otherwise be required by the Securities Act, either the Federal Securities Act of 33 or the state Securities Acts. And every state in our union has a state Securities Act that applies as well to the issuing of securities by any issuer. And you have to comply with any and all of those depending upon what jurisdiction you're in and where you're offering and those sorts of things. So, but beyond that, I wanted to talk generically today about offering disclosure. What is it we're supposed to tell people in a securities offering? What are we obliged to tell them? And what is it prudent to tell them because of the various characteristics of the laws that we're subject to as an issuer, right? So that's what we wanted to kind of talk about today. And a bunch of this is going to be sort of patently obvious, but I want to take you through the discussion. And this particular page has kind of the outline of things on it that we'll talk about today. Probably a little longer than, unless I hustle through things, a little longer than we want it to be. Let me say, just like every other subject we talk about, the topic of securities offering disclosure could literally be a 3-day seminar. 8 hours a day. You could spend an entire subject matter class in college or law school just on securities offering disclosure. It's that broad a topic and it has that many different nuances and elements to it. Let's go to a basic question though. We talk about this in the securities offering set that piece that I did last year, but let's review it here because we haven't talked about it before. And that is, in order to figure out what disclosure we need to make, we need to figure out whether we have a security and what a security is, right? So the question is, what is a security? You guys tell me without looking at the Howey definition, what do you think of when you think of the word security? What does that call to mind?
Investment of some sort.
Okay, an investment. Give me an example of an investment.
Like buying a share of a company.
There you go, stock, right? Stocks. What else? What other kinds of things are typically the next word right out of your mouth when you talk about, for example, publicly traded securities? What would the next thing you'd say? There you go. People say it's stocks and bonds, right? Okay, so stock is a security. Stock is an equity interest in a company, right? Participates in profits and losses and is subject to the risk of failure, also the upside of gains, right? A bond, it's a debt security, not an equity security. It doesn't participate in the upside. I mean, you can do anything you want with debt just like you can with equity, and you can make it quasi-equity and do all kinds of things with it. You can attach warrants to it, which would be participations in upside. You can do all kinds of things. But your straight bond would be simply a debt instrument, right? The lender is loaning money to the company under a bond indenture that's a fancy word for a loan agreement. Right? Through a trust arrangement with a trustee and those sorts of things. And they're collecting money from the borrower, trustees collecting money from the borrower, and under the bond indenture simply takes those collections of interest and principal paydowns and shoves them onto the lenders, the underlying lenders, the group of lenders that are in the bond lender group, and they get paid off and they get interest on their money, basically, right? They get their money back. So that's still a security under securities law, and it's why bond offerings in the public market have to be registered, just like a stock would have to be registered, or a limited partnership interest. You've probably heard of master limited partnerships. There are large limited partnerships. Often REITs, real estate investment trusts, are created as limited partnerships. And they issue limited partnership interests, not shares of stock, which would be a corporation, but limited partnership interests are offered. Those are also securities. So this is the importance of understanding the definition of security now. And so we'll go to the Howey test. Howey was really the first, the seminal U.S. Supreme Court case that was decided under the 33 Securities Act that helped us determine what is a security really? And there's a definition in the Securities Act, 2.1, I believe it is, in the Securities Act, the 33 Act, that tells us what a security is, but it uses terms, and I've included it here, it uses terms like certificate of interest or participation in a profit-sharing agreement, investment contract, and in general, any interest or instrument commonly known as a security. Well, we've just come back to what you just said. Any instrument commonly known as a security, oh, well, stock or bond. But what's all the rest of that stuff mean? And Howey, the Howey versus SEC case, is the case in which the Supreme Court decided just what the limits or sort of general concept was in considering, in that case, an investment contract, what was referred to as an investment contract. It was actually simply a series of documents in which a promoter was selling interests in an orange grove, citrus groves in Florida, and they weren't getting, the buyer wasn't getting a deed or those sorts of things. They were simply getting a participation promise in profits of the operation of the citrus grove. Right? So there wasn't, a certificate being handed out or those sorts of things. It was just a series of contract documents. And the question is that an investment contract for purposes of the Securities Act? And the Howey court said, absolutely it is. And here's why. So read the part I've highlighted in yellow, because this is the thing that has stuck ever since. And that is, whereby a person, any contract, transaction, or scheme whereby a person invests his money in first of all, requires an investment, in a common enterprise, not exactly sure what that means, but we can talk about that, common enterprise, and is led to expect profits, element 3, solely from the efforts of a promoter or a third party. 4 basic elements in that sentence that are required to find a security for purposes of the Security Act. Well, an investment contract for purposes of the Securities Act. But if you think through that, that could virtually mean anything that 2 or more people get together, create by joint efforts an expectation of profits, and one person puts in money and the other one puts in management. That could conceivably be an investment contract arrangement that the securities laws apply to. All right, so without getting, kind of way down deep in those kinds of weeds and exploring the limits of that, I wanted you to hear that definition because I want that to ring in your heads for the next 50 years, right? Anytime you think of other people's money, using someone else's money in a project, remember the Howey definition in your head and realize that it's very likely that that securities laws are going to apply to that investment, and you need to make sure you're paying attention to the detail and getting it done right, okay? And usually what that means is, as we have in our practice, we find a private exemption, an exemption from the registration requirements of the 33 Act. In other words, we don't want to have to go do a public offering like, let's see, where is it? I gave you 2 large handouts today. I gave you one of our private placement memoranda, and we'll flip through the risk factors in that one today. And then I also gave you a Reg A offering right off the SEC's website, a Regulation A offering, which is a small market cap offering. Usually, there's actually 2 parts to it, usually under $20 million, but it can now go up to $50 million. But it's a Reg A offering for a small public offering by a small company. And this is one you can go on the SEC's website, the Edgar website, you can pull all kinds of them. And I just happened to pull one. This is not intended to be specific. I didn't target this one. I just pulled it because I wanted you to see what the format looks like, and we'll talk about that in a second. What the format looks like, how it's a bit different from our private offerings, but essentially lays out the same kind of information that needs to be disclosed. So anyway, so you'll see 2 pieces here. All right, so we kind of now generally know what a security is, and so then the next question is, assuming we have a sale of a security, why do we disclose or need to provide information to the person whose money we're asking for? Well, there's a whole series of laws, the securities laws, that really are the source of why you have to give that information. But let's be practical about it. If I were going to ask you guys for $1 million for a project that I was going to do, would you write me the check? What would you want to know?
Terms and that I have protection.
Okay, so basically the word is everything. Right? I mean, a safe word in the context would be, hey, I'm giving you money, I want to know everything. Tell me everything. So we have economic reasons to do this. It isn't just that the law tells us we have to do this stuff, or we're kind of not very smart if we don't, right? But as a practical matter, we're not going to get people to invest in our projects if we don't give them the relevant detail, right? So it's the economics that are really driving the information that goes out in projects. Let's assume that it's a small group of us, a small band of us. Let's say you guys get together with 3 or 4 people 15 years from now, you've all been successful, you all have a bit of money independently, and you find together, you've been talking over the years, having beer on game nights or whatever, and you decide you want to do a project together. Somebody has come across one, and you want to do a project together. You go, hey guys, this is really great. Okay, well, you guys call that guy and call this guy, and we'll get these guys together. I mean, it'll be fraternity, sorority, whatever, our friends from school, and we'll get this thing together. Let's go. And let's assume it's a small group of people. It's this group right here. And the 6 of us are sitting at a table, and we negotiate over the deal. We decide how much money we're going to put in. Let's say I'm the only one that doesn't put money in, but I'm going to provide a lot of the managerial resource because I have expertise in the particular area. And you guys are going to be involved too, but not nearly as directly on a daily basis, right? Are we going to have a security? Is you guys' investment in this joint project a security? I'll give you the answer. Probably not. Probably not. Why? Because you guys are probably going to be a bit more actively involved in the project, in its execution, in its management. You are not looking solely, was that word in the definition, in the highlight? Yeah. You are not looking solely to the efforts of the promoter or a third party to provide those profits. You're now going to take some sort of role in it. It may not be as active as mine, but you're going to take some role in it. As a result of that, we call that generically the partnership exemption. And there, by the way, there isn't a partnership exemption in the securities laws. But we refer to it as that because if that's the case, if we're agreeing to do this as a partnership together and we're going to be involved together, then it falls outside the definition of investment contract under the Howey definition, and therefore it's not a security. Okay? So we get together and throw a partnership together. It's not a security, despite the fact that somebody comes in and puts money in and the other guy brings all the expertise to the table, assuming the guy that's putting the money in is not doing it solely with an expectation of profit into a joint enterprise, solely looking to the other guy for management and return of the profit. Okay? As long as the other guy's involved in the process, then we don't have a security. And so we don't have to worry about exemptions and all those sorts of things. And at that point, it's just a contract trade, right? We're sitting down, we're talking about the project all the time. I keep you up to date. You keep asking questions, and we figure out what to do next at every turn as the project goes on. It's just a project, okay? So I wanted you to see that distinction before we get there, all right? So let's go on. So source of law. Assuming we have a security and we're subject to the Securities Acts, we've got the 33 Act of the Federal Securities Act of 1933. We've got the Securities Exchange Act of 1934, which covers some slightly different stuff, and we'll talk about that in a little bit briefly. And then you've got state securities acts that I mentioned before. Every state in the country has a Securities Act that you have to comply with unless there's a federal exemption from having to comply with the State Securities Act, okay? So, and there aren't many of those, by the way. But we do have them, and in fact, we use that one of those exemptions regularly in every one of our private offerings, so that we don't have to register under state securities acts in our offerings. All right. So assuming that's where we are, then the other reason that we provide information, not only so we can get a deal done and so we can comply with the law, but is to avoid future misunderstandings. And that can be a real problem in the securities area. Obviously, anytime we go out with a securities offering, and I believe if I have my page count right, this confidential offering memorandum for TC21 was 68 pages long. And it's in, I think that's 10-point font, but it might be 11-point font. It's a lot to read. Very few investors actually read their way through these things. I know only a few of, or I've heard only of a few of our prospective investors, our regular investors or our investors at all, who actually read through all of what we write. And we write every word of that on every one of them, every word. It's gone over a number of times by a number of lawyers to get this done, to get these things done right. And this is not the only document that we're writing in connection with these transactions. Working on one right now that involves 3 or 4 different documents that have to be done to properly describe and set out the deal. So there's a lot of work that goes into them, but there's a lot of reading and a lot of disclosure. And the reason we do that is to make sure that we're giving people the information they need to make an informed decision. We don't want to leave anything out. Now, one of the things we do here at RREAF, those of you guys who've been around or involved in underwriting know that when we do an offering, we do what's called an equity request. The folks over in underwriting over there do all of the hard work, all the diligence and all the number crunching and everything else to put the business models together, to look at the underlying business that we're acquiring or the properties we're acquiring, how that portfolio is going to work together, how the financing is going to work, and how the whole capital stack is going to work, and make sure that as the business is improved, cash flow is improved, and those sorts of things, we have some expectation of what the profit's going to look like on the other side, and therefore what distributions are going to look like, economic value is going to look like to the offerees of our offerings, right, to the prospective subscribers. So what we try to do in our disclosure is we try to make sure they understand the business deal, and that's what you were talking about earlier, right? Everybody wants to know the business deal. The business deal is largely described in that, for us, in that separate document. As lawyers, we try to be pretty careful to not restate or try to reinterpret or re-narrate what the equity request and the numbers in the equity request already say. Because if we try to do that, it's possible we could create some confusion between what we say and what it says, and that just interjects uncertainty in the future, right? So we try to avoid that by allowing the equity request to speak to all the numbers, to speak to those things, and to the extent that we need to summarize any of it, in some cases, if we do have narrative in our PPMs, we'll say, for more detailed information, see the equity request, because the equity request is specifically referenced in our PPM as being a primary document that they need to be looking at. And we give the investors warnings all the time about making sure that they're looking at the equity request, because that's where primary source material is, okay, on the deal. So we want to provide that information to minimize, if we can, there's no such thing as keeping from it, but minimize misunderstandings. So who do we give these disclosures to when we do securities disclosure? Well, if we are involved in some sort of a registered offering, it's going to be to the SEC and to state securities boards or state securities agencies, right? Those would be obvious ones. You also may have a requirement, and we do in some of our situations where we have franchises like our hotels, where the franchise agreement requires us to provide our offering documents to the franchisor, sometimes for review in advance of our going out into the market with them, because they're concerned about any statements that we may make about the franchise and the terms of the franchise or our relationship with the franchisor and those sorts of things. So there may be contracting situations that you have to be aware of when you're doing these kinds of offerings to make sure that you don't step on a contract problem. So make sure you're checking back with your lawyers and the folks that are involved in the material parts of the business before you jump into making a disclosure about something that has to do with a third party. We had that come up in our Galveston land project and in our Myrtle Beach land project recently, the acquisitions of those two, because there's a particular proposed franchisor that we have been negotiating with over franchises for both of those locations, that we're concerned about having that name go out into the public, out into the market with those offerings, and what that exposure will mean without having permission from the prospective franchisor. And furthermore, we don't have an agreement with the franchisor at that point. It's just prospective. We're talking about it, and so we disclose it in the offering materials as prospective, but we generally don't name the franchisor. And we also limit the amount of detail that we can give, that we do give and that we can give, just simply because there are restrictions on our ability to do it. So that's another thing. And then prospective investors is the obvious party that you're preparing. So that's the why do we do this, and who do we do it? Who do we provide these disclosures to? How do we disclose? Well, we disclose usually through some form of written offering document that summarizes either a private placement or confidential offering memorandum or a public offering circular. This is called an offering circular, and it could be under any number of rules that the SEC has issued. You've got Regulation SK, Regulation S, Regulation A. There's a number of different rules under which offerings can be conducted, public offerings can be conducted, and those rules depend on the size of the issuer and whether whether that issuer currently already has securities in the market, whether it's a foreign issuer that's issuing in the United States and the like. There are a number of different reasons why different parts of the securities laws are used by securities lawyers in pulling offerings together. So there are a number of different ways we do that, and at the end of the day, we're disclosing usually either in a public setting through an offering circular. And by the way, an offering circular and a public offering usually goes through several rounds of edits with the SEC and with the state securities boards. So the issuer will be required to draft something up in a format like this one that is dictated, by the way, by the particular regulation that you're issuing under. The format is dictated, and we'll talk about that in a second. In fact, flip with me to the second page on the back side. You'll see on the circular, the offering circular for, what is it, Yayo? Flip to the third or fourth page, and you'll see this. You'll see the table of contents. Flip to the table of contents for me for a second. Let's just have a look at that. This will be helpful as we move into this next part of the discussion. That is, what do we disclose? So this is the sort of thing that is required by public disclosures. And in fact, if you'll do one more thing for me, grab our private placement memorandum and flip a few pages back, about 3 pages back, and you will find the table of contents in the private placement memorandum also. Okay? And what you'll see is some real similarity between them. They aren't identical. They don't need to be. The first one, the offering circular, that particular order and presentation are dictated by Regulation A. The issuer is required to follow that format. And if you look through very many public filings, you'll see this format consistently. They put it in an order, and the SEC's decided by rule that order is the best way to describe things to parties who may not know, who need to have some information and not be confused by it. So the SEC's decided how you do it, and then they even give you instructions on the forms, and lengthy instructions in some cases, about the kinds of descriptions you should be using and what you should not be doing. The state securities boards do the same thing. Under regulation crowdfunding, the Texas Securities Board has a section, has an entire page just on regulation crowdfunding in the state of Texas, and what that offering circular needs to present, what it needs to look like, the order in which it needs to occur, those sorts of things. And obviously they can't tell you what to say, but they can tell you what order to say it in and what things to include. Right? So just understand that when you're working through, especially in a public setting, in a public offering setting, you're probably going to have to follow the rules very closely and present in a particular order. In our case, in the private offering area, we don't have that requirement. We can present in whatever order we want to, but general standard is you pretty much present in the kind of order that you would see in these public offerings, because it helps people to understand what they're looking at when they see it in that sort of order. So we try to keep it in some rational form, irrespective, either side, whether it's dictated to us by rule or it's simply our presentation, one way or the other. So, but the issues we try to cover are pretty similar. So let's move on beyond that. So that's how we disclose. And then what do we disclose? All right, so I've given you, and this is the last section that we'll spend the rest of our time together, next 10, 12, 13 minutes, just talking about what it is we disclose. So let's be practical about what you disclose in offering disclosures. First of all, I need to know who it is I'm investing in. So I need to know about the issuer. Secondly, I need to know what that security is going to be, right? You're going to look at that page. Yep, the one that has the yellow in the front of it, and flip over to the third page, to page 3. On the front, that page. There you go. So that'll be the listing we'll talk through right now. What do we disclose under item 5? Obviously, you're going to want to know about the issuer. You're going to want to know who the issuer is, where their primary office is, who their people are, who the primary officers and principals are, who the primary shareholders are in the company, if there are any at that point. You're going to want to know about the company's, and then you're going to move into financials. In many cases, you're going to want to know about the company's operating history, if it's been around for a while. Show me your financial statements. In other words, how well have you done with what you've done up to now? How much money have you already raised and used? What were your sources of funds? What did you do with them? What do you now own? What do you expect to own? And then we get off into financial projections, or what the securities laws refer to as forward-looking statements, that we do projections on what those, not only the historical financials that we've now laid out and discussed, but then in addition to that, what we think will happen into the future, what we believe will happen based on our projections of employing the money we're trying to raise now, the capital we're trying to raise, how are we going to deploy that money, and how's that going to make our business operation bigger, better, more profitable, those sorts of things, right? We want a full description of that. So we want good financial disclosure. And part of that financial disclosure is not going to just be the numbers. And you'll see this in some of the discussion about narratives. We spend a lot of time, and that's essentially, I mean, if you flip through, for example, our private offering memorandum here, if we flip through this together very quickly, you're going to find that there's very little of, let me see if I can even find one. Well, I know they're in here, so let me just find it. You're going to find very little of this. You're going to find very few charts, numbers, because all of that's contained in our equity request, where all of the real financial analysis is, where all of the numbers are. So we don't spend any time in our private offering memoranda regurgitating, as I said before, regurgitating the numbers and the process, unless we simply want to make a point, as we've done here, that this piece in the equity request, this is a chart copy right out of the equity request, is merely a capitalization table that assumes certain things will happen in the future. So that disclosure is called Investment Projections Assume Certain Conditions at the bottom of page 20. It's a risk factor. Investment projections assume certain conditions. And it's a narrative description that says, hey, wait a minute, just a second. I know you're over there looking at those investment projections in the equity request. That's great. It's exactly what you need to do. But you need to know that those projections are merely estimates. They're not promises. They can't be promises. They're forward-looking statements. And because of that, you can't rely on them. Okay? One of the things we do in securities offering disclosure is make sure that people understand the parameters of the investment. Look, I can't, this is not a crystal ball. As an issuer can't project into the future and know with any, real level of certainty what might happen. Could we have predicted COVID? Heavens no. Could we have predicted any number of things? Could we have predicted, Russia and Ukraine? We can't. So things are going to happen, and the question is, what do we do in our offering disclosure materials to make sure that we've done just about everything we can to put the regular risks, the things we should be thinking about as investors, out in front of the investors, just to make sure we've piqued their interest in or piqued their thought on any particular item that could be of issue. In particular, we need to make sure in our offering disclosures that we don't just cover all the, and I'm going to use a phrase that gets used out of an old movie you may or may not know, the usual suspects. Okay? We don't want to just talk about the usual suspects. Risk of interest rate changes in the market, right? Risk of competition, competitive properties or competitive developers or those sorts of things. That's all standard stuff. And while we put that standard stuff in our PPMs, we really want to try to take time to learn the business that we're going to acquire or that we're raising money for, and customize the description of the risk factors into that industry and into that particular project, so that people who are reading through this have an opportunity to see what we see as insiders, what we see as experts in the business that could be at issue in this particular transaction. That's what we try to do when we do offering disclosures. So historical financial statements, price, amount, capitalization of the securities that are being offered, right? I mean, people need to know that. How about dilution? Wouldn't people want to know whether they could be diluted in the future? Sure. We include likelihood of dilution in all of our offering, all of our offering memoranda, because there's a possibility we may need to raise more money in the future so that, for example, the bank loan can be paid if the business goes into a COVID recession type problem again unexpectedly, and rents go from 96% occupancy to 82% occupancy, and all of a sudden we can't make debt service. Right? What do? We may very well have to go back out in the market and raise more money to be able to get us through this situation. Businesses tend to fail generally for lack of capital. Small businesses tend to fail for lack of capital most often. And so it's entirely likely that we may need to go back out in the marketplace during the course of any given investment. So we have to talk about prospective dilution, what that would look like, or at least warn them that it's possible. And then we have to reserve in our documents, the rights to raise more capital if we need to. Right? So important that we do that. So not just historical stuff, but also the securities that are being offered, management, our history, our qualifications, what we do, how we do it, what we've been successful at, prospectively what we've not been successful at. Needs a remark or two. Specific risks of the investments. I've laid out a number of specific categories of investment, of factors. So special industry factors. For example, if you're in the defense industry, you're probably pretty reliant on some really, really big customers, one of them being the federal government. Those would be the sort of things we'd be talking about, we'd be disclosing. If it was a regulated industry like food, like a food services business, we'd be talking about the necessity of licensure and keeping up with compliance and the risk of possible non-compliance and the business being shut down because we failed to comply adequately with the minimum license requirements. Right? Any sorts of things like that need to be discussed when we talk about those, when we do an offering memorandum. Employment and compensation, especially for the higher paid folks in the business, especially the promoters or the sponsors. We need to disclose what they're going to be paid, if they're going to be paid directly by, or even indirectly by the company. So in our offering memoranda, for example, we don't have those sorts of employment arrangements, but we do have management agreements. We have a property management agreement, and we have an asset management agreement or an administrative services agreement, and both of those charge fees to the issuer, right? To the issuer or the subsidiary, their subsidiaries get charged these fees. So we have descriptions of those arrangements and the fee arrangements so that the people who are investing know that affiliates of the issuer, RREAF and RREAF Residential, are being paid management fees to manage this management for them, for the investors. Dilution, we've talked about that. Taxation issues. You'll find 3 or 4 or 5, 6 pages on taxation issues in our PPMs. Limitation of liabilities. We'll often talk about, in fact, we do here in Texas, there's a limitation of liability under the Texas Securities Act that specifically makes it into our PPMs. Key personnel, we've talked about litigation and legal proceedings. If we're involved in material litigation or legal proceedings, those need to be disclosed. We disclose those confidentially only to specific investors who ask for them, because if it's active litigation under advice of counsel, we don't disclose out into our offering documents. We simply let them know that there may, from time to time, with respect to specific properties, be litigation or litigation that's even involves RREAF Holdings. And if they want more information about it, subject to attorney-client privilege and rules of confidentiality, we'll provide that to individual investors on their request. Right? You'll get the size of the offering. Use of the offering proceeds is an important disclosure, discussing how the offering proceeds are actually going to be deployed. So you'll see in our equity requests that we have a full page or 2 or sometimes 3 on how the offering funds are going to be deployed into the acquisition of a property and its renovation and those sorts of things after the fact. And that's usually, sources and uses of funds usually not include, or do include not only the equity, but also the debt. The full capital stack will end up being in that kind of description. And then risk factors and risk factor qualifications. We sometimes qualify risk factors, and the securities administrators don't much like it when we do that, although in some cases it's just prudent to have to do that, to qualify or limit the range or the breadth, the width of a particular disclosure. In some cases, because there are facts at issue that we may not know or be able to control or even assimilate into a narrative at that point in time. So these are the kinds of things that we run through. If you flip through the back end of either one of these, either the circular or the PPM, you'll find a section entitled, starting on page 37, called Risk Factors. And the next 20 pages or 25 pages of that document or so, 20 pages or so, is a description of the specific risks that we want investors to know about in that particular offering. They change from time to time. We modify them, customize them, but they tend, especially since we tend to buy the same sorts of properties, either hotels or raw land or a multifamily. In each of those settings, our risk factors are adjusted to address those particular kinds of projects, and usually the geography in which the property is located. So that's securities offering disclosure, kind of a really high view overpass on it.